I request our dignitaries to come on the stage. Let us commence this ceremony with a lamp lighting ceremony. Lighting a lamp is not just about dispelling darkness, but igniting the flame of curiosity and learning. And I would like to humbly invite the dignitaries to light the lamp. Thank you, dignitaries. Now I will invite Bhakya Lakshmi Ma'am, Assistant Professor, Department of Law, and Program Convener for this event to deliver the welcome address. The floor is yours, ma'am. Thank you so much, Avilya. Very warm good afternoon to the dignitaries present in the dais, esteemed faculty members, staff, and students of the Central University of Tamil Nadu. It is a real privilege and a real pride for the Department of Law. This event is being planned as part of our ongoing celebrations of Constitutional Day. And this is also quite special to us. Today we have officially found memorandum of understanding with National University of Advanced Legal Studies with a vision for imparting socially relevant legal education with academic and research collaboration with the National University, a very prominent institution National Art School in Cochin. So with that fact in mind, so today's lecture is with respect to our Constitution, the landmark of our country, which details the ideas and the values of the nation possesses, and the specifications which have been detailed for the protection of children within our Constitution. And this has welcomed the legitimacy with respect to special statutes that have been formed for protection of children, especially from the benefits issues like child sexual abuse. And we do have today a young scholar and an academician who has relevant experience with respect to this aspect. And now has been a prominent academician who has worked on sexual abuse. And what makes it quite special for this lecture is that she's kind of correlating that with the Indian knowledge system to let explore in the legal discipline and to, you know, to showcase how the values complicated with respect to Constitution and also with respect to the case as such. With that thought in mind, I would like to first welcome our dean, Professor G. Ravinder sir, who has been a pillar of guidance for all of our endeavors we have come across this. So, and foremost, I will welcome you, sir. Next, I would like to welcome our HOD, Balashanmugam sir, who has been a unflinching committed person to our department, who has been and called for everything that is related to our department. So I welcome you, sir, to this event. I would also like to welcome our faculty today, Dr. R. Chandrasekhar, who has been very familiar with respect of organizing this event. I welcome you, sir. Also, would like to welcome my staff at the Department of Law, who has been fully supporting us on this and the students of Department of Law. And not just this least, but I would like to welcome all the faculty who have taken it very seriously and have come for this lecture specifically. And also to all the wonderful crowd I am seeing over here. I'm very optimistic that you will get more insights from that regarding the session which she is addressed. And thank you so much once again, and I welcome you all to this event. Thank you. Thank you. Now, Director, Dean, School of Legal Studies, Professor G. Ravindran sir, and our Chief Guest with a star and a momentum. Thank you, sir. Now, first, Department of Law, Dr. Balashanmugam sir, to honor our Dean with a shout. Thank you, sir. I would like to request the Dean, Professor G. Ravindran sir, to the curriculum address.
Good afternoon, dear faculty members, students, and first of all, let me thank our esteemed guest for coming all the way from Ernakulam to sign the MOU with CUTM and be present here for the lecture. Thank you, madam. And I have been having little conversations with madam since morning, and also with our vice chancellor. And I am sure this first MOU department has will pave way for many laurels for the department and the university. Our Vice Chancellor is very keen that the students of our department should be visiting, hopefully by the coming month, Madam's University, and we have been making preparations and arrangements. That is the first byproduct of this MOU, today's MOU. And our Vice Chancellor and Madam also are interested, keen to have a credit transfer on credit transfer basis, an elective course between these two institutions. Madam's institution is the pioneering one in terms of what it offers as courses, the locational advantage, and we also have certain advantages in our department. And we will find the right synergy in the coming days to take this MOU forward. And I'm hopeful that our students, scholars, and faculty members will benefit a lot. And at this moment, I need to say big thanks to the young colleagues in the department, led by Balashanmugam, Dr. Balashanmugam, Dr. Sangeeta, Dr. Bhagyalakshmi, and Dr. Chandrasekhar for making this a reality. Particularly, I'm told that Dr. Bhagyalakshmi has been very proactive in having this relationship with Madam's Institute. Thank you, Ma, for this. Without you, I know we won't be meeting today. So, big thanks to Dr. Bhagyalakshmi in this regard. And I always tell our Vice Chancellor and authorities that our department is unique among the 28 departments. In one way, all the 4 faculty members, even though it is understaffed department, university authorities are making efforts to fill the vacancies. The process is underway. Hopefully, we will have 2 more associates and 1 more professor in the coming days. But in the meantime, these 4 young faculty members are compensating by that proactive attitude. Thank you very much for. I often say that I can give advice, many of our colleagues, but not all the colleagues would be proactive in implementing the suggestions. So I find in this group a very different group who not only listen and who are very receptive, but are also keen to implement what all we have been discussing, what all Vice Chancellor has said. And I wish the department many more laurels in the coming days. The topic of the day is very interesting because it connects you with what has been forgotten as tradition and what is seen as a huge stumbling block, that is tradition too. Okay, so tradition comes in the way of whatever legal mechanisms our country is seeking to put in place. Tradition is seen as a villain. Tradition is seen as a culprit also. Tradition is the villain of law also. So, but it is a one-sided judgment, I think. If you are going to blame everything on tradition, it will be a one-sided judgment. I don't want to take it. We also need to learn a lot from tradition and traditional practices. Traditional practices do not flow from the side of society only. Traditional practices do flow from the side of our modern courts, ever since they were put in place by the colonial rulers. The modern courts have been the sites of these practices. And some of these practices are forgotten now. The best practices of the judgments were thought about and done collectively, and how the classrooms were operating some 100 years ago in law colleges. Some of these best practices have been forgotten, and I am sure that with Madam's lecture, we'll be able to remember, recollect, and wherever possible, we can revive some of the best practices, okay? The traditional, so-called traditional practices in law classes, courts, etc. Thank you very much for this opportunity, dear colleagues and students.
Thank you so much, sir, for your kind words. I would like to invite Ramesh for his introduction.
It is my privilege to introduce our speaker for today, Dr. Lina Mathu, a registrar of the National University of Advanced Legal Studies, Ernakulam, an eminent academician in the field of legal education and research with over 16 years of teaching experience. And she is alumna of Government Law College, Thiruvananthapuram, and National Law School of Indian University, Bengaluru. She holds a PhD from Queensland University of Technology, Australia. She had authored several publications focusing on legal education, information technology law, and laws concerning with women and children. Reflecting her deeper engagement on these domains, we welcome you, ma'am, for the session on topic bridging traditions and justice from a constitutional perspective, a child sexual abuse and the Indian knowledge system. The honorably welcome.
Respected Professor D. Ravindran, Dr. S.K. Balashanmugam, Dr. Chandrasekharan, Bhagilakshmi, other dignitaries of the dais, dear students. Thank you for hosting me here and giving me this opportunity to speak on the topic from my heart, that is on child sexual abuse. That too, from a constitutional perspective, and also to have a discourse on what are the Indian knowledge systems or how these concepts, which perhaps from the we have borrowed from other countries, the current laws that we have on child sexual abuse are borrowed from other countries, and how our experience in India would actually, or how we, since it has already been implemented, how the reception is happening, and what we can do or we ought to do to strengthen such from the justice perspective, how these kind of abuses can be prevented. So that is what I plan to focus in this particular talk. So I would like to first bring to your attention the Indian Constitution. I understand that many, especially those in the media, classes already. You have studied, you have a course on child rights, and you already deal with certain aspects of the Indian Constitution. You have already referred, you have knowledge about that. But to those from other disciplines, I understand people from students from commerce, students from economics, and is there anyone else? Education. Yeah. And yeah, media. I already understand you are here. I said that you already have, you are aware about children's rights and from a constitutional perspective also because you have a course on it. Whereas the other disciplines, I mean, other than commerce you do have corporate laws, but otherwise the, uh, the topic of children's rights is not something that is commonly discussed among other in other disciplines. So, in the Indian Constitution, we have Article 21A, which guarantees the right to free and compulsory elementary education for all children in the age group of 6 to 14 years. There is Article 24A, which secures the right to be protected from any hazardous employment until 14 years, and also the other rights, like the right to equality under Article 14, the right to personal liberty and the process of law under Article 21, the right to being protected from being trafficked and forced into bonded labor under Article 23. So all these constitutional guarantees are there, and the laws that emanate from the Constitution the laws which emanate from the Constitution are supposed to give backing to these particular rights and freedoms that are embodied in the Constitution. So, there is the United Nations Convention on the Rights of the Child, 1989, wherein a child was defined as a person below 18 years, and the of non-discrimination, the best interest principle, etc. They actually they found place in the Convention of the Rights of the Child, and later on they were incorporated through various court decisions into the general law of India, the law of the land. The right to life, survival, development, the right to express views, children's right to express views, and the right to participate in decisions. These have also been mentioned in the UNCRC. And then we have adopted the UNCRC, India being a signatory to this particular treaty, it means that we have to adopt these principles into our general law also. The general law of the land, either criminal or even other laws. So, children's right to express their views, the right to participate in decision making, that actually perhaps we do not find the embodiment today, but hopefully in the future, these can be brought about through different laws. Then, with regard to the rights of child offenders, in my last line, you can see that child offenders are to be treated in a manner that upholds their dignity and value, reinforces their respect for human rights and fundamental freedoms, considers their age, facilitates the society, and encourages them to assume responsibility for the future. So, the Juvenile Justice Act, in which child offenders as well as child victims are dealt separately, that actually has to facilitate the reintegration of child offenders into society so that they have respect for human rights and the fundamental freedoms. And also, later on, they would assume responsibility for the future. To look into the different types of abuse that children encounter, there are various studies that have been conducted And basically, it has been divided into four: physical abuse, sexual abuse, emotional abuse, and girl-child neglect. That was how the Tucker Committee report in 2017 uh, classified the different types of abuse that children encounter. You can see that the first definition about what is child sexual was in the World Health Organization report of 1999, which stated that child abuse is participation of a minor in sexual activity that the minor does not fully understand, cannot consent to voluntarily, or which violates societal norms and legal statutes. So when when a minor, a child below the age of 18, does not fully understand what sexual activity the child is undergoing, supposing the child is undergoing it, but the consent of the child, whether it is voluntary or not, that is another question. Whether the long that the child cannot enter into a contract, or the child's consent itself cannot be said to be as real consent. So, if the child cannot consent to sexual activity voluntarily, or the child is undergoing a sexual activity that violates the societal norms and the legal statute, that is defined as child sexual abuse in 1999. That is one of the earliest, or perhaps the earliest definition of the term child sexual abuse. At the time when this particular act itself was not discussed at all in India. In 2007, I'm sorry, I already said 2017, it was actually 2007, the Ministry of Women and Child Development report, they brought out a report known as the Kakkar report. Later on it was called, Kathleen Kakkar was the chairperson of the Ministry of Women and Child Development, or the Secretary of the Ministry of Women and Child Development, and she brought about this. She pioneered this report called the Study of Child Abuse India 2007, which reviewed 13 states. And data was collected from 13 states. At that point of time, what data collection was not the type of data collection that is done today. So it was very basic, you can say, but still 13 states were, the data was collected from different social organizations, NGOs, etc. And it brought out a study on child abuse. And it was in that report that these four categories were identified as physical abuse, sexual abuse, emotional abuse, and neglect. So, in sexual abuse, the Thakkar Committee report 2007 in India for the first time gave a definition of child sexual abuse as inappropriate sexual behavior with a child, and it included different types of sexual behavior, and to be considered sexual abuse, or to be considered as child abuse generally with regard to the four categories. In order to be considered as child abuse, these acts have to be committed by a person responsible for the care of the child, and or it has to be committed by a person related to the child. So, who all were the categories that the report stated? The babysitter, parent, neighbor, relative, extended family member, a peer, or an older child, or a friend, or a stranger, or a daycare provider. So, a stranger came under kind of a person who is responsible for the care of a child or related to the child. So, a person who is a responsibility, or a person who is in a fiduciary relationship to the child. So, any kind of sexual act committed by a person in a fiduciary relationship with the child would be considered as child sexual abuse. Now, to look into the context of child sexual abuse, abbreviation is usually as CSA. And we can see that it was these different civil society organizations and the Ministry of Women and Child Development that engaged constantly from 2007 onwards until the passing of the POCSO Act in 2012. Many years they were engaged in helping to break the conspiracy of violence. That is what it was called. It was called a conspiracy. No one was interested in talking about the rights of the child. There are people who are seen and children are considered as those who are seen and never heard. They are not invited for discussion. They are different. Everybody takes care of the child, but nobody asks the opinion of the child. And also, are not considered. They are vulnerable groups who are not empowered enough to talk. Because we have the sufficient mental development, physical development to make themselves their voices heard. So, a conspiracy of silence was said to surround the entire issue of child sexual abuse. So it is stated that these civil society organizations and the government of India engaged in helping to break the conspiracy of silence by getting the POCSO Act of 2012 enacted. And we can see that there were different reasons for such kind of case. One thing was that because us being a developing country, we did not have enough financial allocation for women even today. So that it does not provide, or perhaps better than earlier, but still not sufficient. So there was improper documentation. So when the Ministry of Women and Child Development conducted that study in 2007, they asked randomly to provide data. It was not that the data was certified or anything. They just randomly requested the different NGOs and maybe different the governmental organizations were not properly staffed enough to even provide the data. So some data occurred randomly at that particular point of time. So we can see that there was improper documentation because of inadequate allocation of financial resources. But right now, we can see that the NCR International and Record Bureau, now they actively collect data with regard to child sexual abuse cases that are registered in the police station. They also give a breakdown under which particular section that of the Indian Penal Code or the BNS, the current BNS, that the offender is being charged, or which particular provision of the POCSO. There are different categories of sexual abuse under the POCSO, penetrative sexual abuse, sexual assault, then cases with regard to pornography, and even in the Pornographic Act itself, a different type, penetrative pornography or just sexual assault pornography, etc. So the different categories in the POCSO, and those NCRB data details as to which section itself, under which section the particular offence was committed or was charged, offence was charged before the police station. And also we have the e-court system. Right now, with regard to the POCSO cases, which are registered and which go before the court, even if you access the e-court site across the states in India, you are probably able to get the data from the e-court system. Then, with regard to the legal system, what is earlier, even 15 happens is what I heard. You can see that ultimately, after the child is raped or the child suffers sexual assault on the hands of the perpetrator, when it goes to the court, and the systemic delays that happen in the court itself, then because of when the child comes before the court and the child is cross-examined, the child is re-examined, etc. That time, the trauma that the child suffers from the hands of the in an open court, sees the offender. If at all the offender is brought before the child and the child sees the offender, the trauma that the child undergoes there. And in the courtroom or in the court corridors of the court, when the child will be waiting from morning till night till the or from morning till evening till the court closes, if the contact with the child comes, or the contact with the relatives of the child comes, the person who accompanying the child comes with the offender and his family or whoever is there who is accompanying the offender. So these kind of circumstances perpetrated even more abuse because we could classify different units would call this kind of abuse suffered by children as the rape by the legal system. So not only they undergo rape by the actual perpetrator, but ultimately the legal system itself rapes them. That is how it was with the re-victimization or the secondary victimization from the terminology is given like that. So without understanding the consequences, the detrimental consequences that occur, because of that, people want to go before the court. People will not want to report before the court. Even if they do report initially after, well, they would turn hostile because they don't want to undergo that any longer. Because the support systems that are given to the children and their families would not be sufficient to want them to take it further. And ultimately, they would feel that it is better to suffer in silence rather than undergo this entire trauma, because ultimately, justice is not served. Justice delayed is justice denied. So that is the effect that ultimately happens, and which prevents people and children and also their relatives also from approaching the legal system. So to look into a historical, just to give you a historical account about the age of consent law that is from 1860 onwards, when the Indian Penal Code came into being, into force in 1860. So then onwards, let us look into the age of consent, with the law regarding who would the law regarding at what age, if a child is raped at a particular age, would it be considered as an offense or not? So, firstly, when we look into, there was a case known as Empress versus Hari Mohan Maitri, in which a girl of the age 10 years, money in 1890. This historical event happened in the year 1890, when Fulmani, a 10-year-old child, who was married to a 35-year-old man, Hari Mohan Maitri, and he had sexual intercourse with her, and then he murdered her. He suffered violence at his hand, and he murdered. And this case came before the court of Calcutta, the Calcutta Sessions Court for trial in 1890, and the mother of Fulmani testified against Hari Mohan Maitri, the husband, her daughter's husband. And at that time, the age of consent for both married as well as unmarried girls was 10 years. Age of consent for sexual intercourse for both married as well as unmarried girls was 10 years. So the court tried to find out what was the age of Fulmani, and it was found that she was above the age of 10. Also, because of which, not given the punishment for this rape, and instead he was punished. He was found guilty for having causing grievous hurt by endangering the life or personal safety of others under section 338 of the IPC, and received a 1-year rigorous imprisonment. That was all that was meted out to him. And in 1891, Lord Lansdowne, the Viceroy of India, introduced a measure titled the Age of Consent before the Council of India, which aimed to raise the age of consent to sexual intercourse from 10 to 12 years. So after 1891, the Indian Penal Code was amended in 1891, and the age of consent for both unmarried girls as well as married girls was raised to 12 years. The first column you can see, I've written the age, the year. The second column, you have the different particulars. The third column deals with the age of consent under section 375 clause of the IPC regime. It talks about the age of consent of unmarried girls. The fourth column, here age is mentioned in the exception to section 375 that deals with the age of consent of married girls. Married girls, girls meaning those below the age of 18. Then we have the minimum age of marriage under the Child Marriage Restraint Act that was passed in 1929. So at that time also, the minimum age of marriage under the Child Marriage Restraint Act was 14 years. And later on in 2006, the Prohibition of Child Marriage Act 2006 came into being, wherein the age of under the Prohibition of Child Marriage Act that was 18 years. So let us look into the historical account to understand how the age of consent of married as well as unmarried girls has evolved. So in the first column, we can see that both married as well as unmarried girls as well as married girls, the age of consent was 10 years. In 1891, after the Viceroy declaration of the age of consent, raising the age of consent, and IPC was amended, you can see that the age of consent was raised to 12 years for both unmarried as well as married girls. In 1925, after the amendment of the IPC, again, the age of consent of unmarried girls was raised to 14 years, whereas for married girls it was put at 13 years. Then in 1929, the Child Marriage Restraint Act was passed, in which the minimum age of consent, the minimum age of marriage was placed at 14 years, and you had the same age of consent for unmarried as well as married girls. Unmarried girls 14, married girls 13. Then in 1940, the IPC was amended again. The age of marriage the age of consent of unmarried girls was 16, and the age of consent of married girls was 15. And again, the Child Marriage Restraint Act was the age of consent was enhanced to 15 years. Later on, after the passing of the Prohibition of Child Marriage Act in the year 2006, the age of consent for sexual intercourse of unmarried girls was still 16, and for married girls it was 15. Whereas the age of consent for marriage was the age of marriage under the Prohibition of Child Marriage Act was 18. This is the anomaly started then, and in 2013, when the Nirbhaya case happened, and thereafter the IPC got amended, then the age of consent for sexual intercourse of sadly, the age of consent for married girls remained at 15. And this was pointed out by means of the independent thought case, which came before the Supreme Court in 2007. And in this case, it was pointed out that huge impact happens when why does the law itself put a differentiation between married girls and unmarried girls. Aren't they, don't they belong to the same category as well? So why put an artificial difference or discrimination between and making these two categories of girls? Uh, why should such kind of distinction be there? And earlier, we all know that when the fear was that marital rape, so long as it was not an offense, that the stigma, I mean, we can actually perhaps part of the patriarchal system, wherein certain restrictions or certain freedoms were to be granted to males because the bondage of marriage, enjoy certain privileges. It was that for that reason that such kind of a distinction was perpetrated. And in the independent court decision, the Supreme Court ruled that there are several severe negative impacts on the repercussions the repercussions on the physical and mental health well-being of young girls, and also child health issues, child pregnancy and mortality, exposure to violence and abuse, educational setbacks, reduced employment and livelihood opportunities, and limited agencies in making life decisions would prevail if such kind of an artificial distinction were allowed to continue. So this Supreme Court decision struck down this distinction between married and unmarried girls, and thereafter, uh, when the Bharatiya Nyaya Samhita came into force in 2003, we can see that now there is absolutely no distinction in the age of consent with regard to married, unmarried, and also under the prohibition of child marriage act. So this is something we have to understand when we are dealing the issue of child sexual abuse, because most of, we can say, in India when we um, have traditionally, child marriage is something that has always occurred in the earlier generations. So we have, or we even, it is part of our system, um, or we have our own independent family and traditions that we carry forward and make us reflect about whether such a distinction would be artificial or whether it is being imposed. So when we come to the past, to answer my background, to understand what is the POCSO. The POCSO is the Protection of Children Against Sexual Offences Act of 2012, which came after a lot of protests from the different civil society organizations. And it was considered as a basic law because in this case, it's not catered to different types of abuses, not punish the different types of abuses in children of and again, the POCSO, it was made not contested. When the case came and the penal code was being amended, were there whether the weight under 75 should be made gender neutral or not. But then the Verma Committee report specifically stated that by making from any man in the section 375 gender neutral, it would reduce the effect of that when people commit rape, they always feel the man should commit that. So it cannot be committed by a woman. So that is the ingrained thought that the Burma Committee highlighted, and the Burma Committee made laws gender neutral. You can see that in 2012 itself, the POCSO Act stated this is the first law within the history of India when gender neutrality was brought about. So even if a woman commits an offense about for a girl child or a boy child, that will also under the POCSO. You can see that this On the issue that the issue was that there was no law on children. Of course, girl children could be perhaps less under the 375, but there was no law at that point in time to with the abuse that happened with girl children. And this is uh, have become high incidence of child sexual abuse uh, among girl children, but there was no legal machinery to deal with it. So in the process of interview, you can see that even boy children were allowed to be protected by only the parents and the nurture. Then, development is realized by also different types of the child sexual abuse was defined in the POCSO, penetrative child sexual abuse, and non-penetrative child sexual abuse, then sexual assault, pornography, coupled with these different types of child sexual abuse, and different remedies and sanctions were also imposed. You can see that basically this law tries to change the court system. So as I had stated earlier, when the child comes to testify in the court, the child is meets the offender, the child meets the offender's family, the child's parents are subjected to these different terms talks by conversations from each side. Then the abusive language or the leading questions that are asked during cross-examination by any such learner. All of these actually it needed to be worked upon, and the POCSO tried to create a child-friendly atmosphere within the court by creating in Delhi, the experiment was conducted in which special courts were identified and there were rooms wherein it was filled with toys and separate entrances were provided for the offender and the child to enter into the courtroom. So this kind of an example was tried to be replicated all over India. So provisions for creating a child-friendly atmosphere to all stages of the judicial process was attempted by the POCSO Act, and it aims to avoid language. So the basic principle of POCSO Act is to give importance to the best interest of the child, which can be seen in terms of the statute as child-friendly mechanism, the abuse, cause of evidence, investigation, legal trials, and camera trials. In camera trial means without revealing the child's identity, the child is kept separate, screen is placed, or the child is kept in separately within the judicial chamber. These are all different methods of in-camera trial. So without revealing the child's identity, designated special court. So one major feature of the POCSO Act is mandatory reporting of child abuse, child sexual abuse. If anybody comes to know that a child is being abused, the law, the POCSO Act mandates that such child sexual abuse should be reported about it. And if you the parents of the doctor who came to know about it, or the nurse who came to know about it when the child is brought to the hospital, such kind of the doctor or the nurse has to file the statement before the police station. And if it is not done, then minimum of 6 months, 6 months or up to 6 months imprisonment can be granted by the court. Also, if the school comes to know about it, it also has the duty to mandate the report. This is a concept that was brought in from other legal systems like the Philippines, where it was successfully done. Then in Australia also, they have a rigorous mandatory reporting law. So based on their experiences, this was tried to be incorporated into Indian context. Is required to report it to the police or to a designated child protection agency, and failure to report child abuse is punishable with imprisonment up to 6 months or a fine or with both. And you can see that different because the mandatory report, the requirement of the law to mandatory report, many doctors were brought before the court. And I've seen personally, or, the special judge of the Foster Court in Ernakulam at one point of time, uh, who came in the lecture at the government law college where I was teaching. Uh, he stated that these people are from, the doctors are of high society. Uh, how can we make them suffer imprisonment? So maybe they would be like this. Status of the respondent or the offender, in this case, maybe the doctor, the judges would allow them to walk on free. So there was no the harshness that the law aimed to, or the law aimed to bring out certain the judges themselves said that these three persons belong to such and such higher social strata, and then they should be allowed to be. So we can see that for different reasons, mandatory reporting fails, or it is continuing to fail. Maybe sometimes you see children are turning hostile, children are brainwashed to turn hostile. Um, with regard to the different cases that come before the court, wherein perhaps the child would be in a romantic relationship, there would not be even a mention of child sexual abuse, or it would be with the consent of the child, a child above the age of 16. With the consent of the child may be encountering or be engaging in such sexual behavior, and maybe willing to may even elope with the other boy. But the boy's parents who report this particular marriage based on various reasons would go and file a case before the court. And ultimately, we can see that the justice system is dragged into unnecessary spending of uh, money, time, resources, etc. But can we say that it is not required? Or can you say that it is required? So that becomes something that leads the debate. And many times we can see judges, they allow they say that there is not sufficient evidence as a result of which the case the accused person goes scot free. And we have um, there are different types of cases which come before the court. And in this, I have brought Justice Sarvan of the Bombay High Court, who stated that the transaction where the individual stands to encompass the society as a whole, and the result of which the child business ultimately turns hostile and the POCSO case, it goes away. So now let us come into the other area that we need to discuss right now. How or what is the Indian experience? And I said earlier, mandatory reporting has been imported from another system. So how do we respond to it? How we respond to it? Also, with regard to the cultural norms, with regard to child marriage, and we know that maybe even our parents may be persons who got married below the age of 18. So the issue becomes complicated in instances where children below the age of 18 get married under customary law. And also we know this part of culture, wherein it is ingrained in their culture itself, and they have a separate section in international law for their cultural. So how can we reconcile that with regard to age difference, then with regard to the voluntary nature of the relationship? So in other countries, when given Hungary, Netherlands, and Canada, there is close in age exception. That is, two children engage in, or two persons within an age gap of perhaps 4 years or 5 years, they engage in sexual relationship. That is given an exception. And the judges are allowed to have their own take on it. But here, because of the POCSO Act, the more if the boy is 18 or below the age of 18, whether or not she actually consented, whether her her consent is not taken into account. The fact that she has the right to autonomy over her body as part of the UNCRC, the right to have a so all those issues are not addressed because of such kind of arbitrary law. The judge is also not given any leeway to decide or to make a decision in the best interest of the child. This kind of issues exist with regard to the POCSO law. We were discussing in the media with the media faculty that many of the laws that we have, for example, Domestic Violence Act, the Dowry Protection Act, again POCSO, these are used as weapons to injure instead of actually help the victim. So ultimately, how do we deal with such kind of issues? And what are our concepts, or how can we deal with the way that culture which does not violate children's rights as women's rights, right to freedom, right to bodily autonomy, etc. So this is something that we have to deliberate upon. And can I have some comments? Does anyone have anything to speak about this on this particular issue, or maybe share your experiences? Anything random, you don't any something so long as it's connected with this particular area. I was speaking certain thoughts were being shared by different faculty about how the POCSO Act is being misused. There are uses of it, but also it is misused also. That happened in the past. If it often happens, actually it should be, it would, there is no bar with regard to, there is no limitation if an offense happens. As per the general principles of criminal law, an offense happens. But if there are societal norms involved, again, perhaps it wouldn't ultimately end up being pursued because child marriage happened in the past. But if an incident of child sexual abuse happens with an unmarried girl, where an unmarried girl is involved or an unmarried boy is involved, so even if it happened in the past, it still can be brought forth now. But again, child marriage is a sensitive issue because it has different religious and cultural nuances attached to it. It would depend again.
I think I'm audible now. Thank you so much for that insightful lecture. I'm very happy because it's been long and have listened to your lecture. And this opportunity has been really enriching for me. I would, possibly be reflecting upon the construction of best interest of the child. So this is possibly the venue upon which the judiciary spends a lot upon the interpretations of, getting the principle. So I think that is one also which the judiciary largely owns in and literally gets into that kind of a passage largely reflect upon. So through this lecture, I was also getting that kind of a thoughts in mind as how well we define the concept of best interest and how do we protect that around? Thank you for bringing that kind of an insight.
Again, the issue when we talk about best interest is who is the one who is going to determine what is the best interest of the child. This is the judiciary. So again, as we studied in, when we talk about Cardoso and other interpretations of law, as to it is the judiciary is basing upon their own cultural interpretation. What one person feels, what one judge feels may not be what another judge feels. So again, what is the best interest of the child will vary from situation to situation. That is when I think the Netherlands law it, gives some kind of a leeway to the judge to decide on a case to case basis as to what would be appropriate for a child in a sexual abuse case. And made one school said that should be given also to Indian judges to determine what would be the best interest of a child in a particular on a case to case basis. Would anyone like to speak?
If both boys and girls,
Yes.
if both are under 18, they involve sexual abuse, so their parents can take the action, legal action against anyone because they don't know, right?
Yes.
In today's social media world, many people they are doing. So their parents they can file any charge cases that I want to.
Yes. So who would be the child victim and who would be the child offender in this? It becomes a question. Maybe both of them are the offenders. You could also say both of them are the victims themselves. So, for example, the Delhi public school case, wherein a boy was, it's very long, it happened long back in 2011, in which one boy he filmed the sexual intercourse of him and his girlfriend, and it was circulated in the media. So ultimately and it was sold to it was uploaded in Bazi.com, and ultimately there the CEO of Bazi.com became the offender, and he was convicted. So there are different dimensions in which this can go, because both of them are children, both of them would be protected under the law. Both of them, so again, that is where the age of consent or the close age exception, whether they should be applicable, because both of them were similar age and both of them were more or less experimenting rather than getting an offense. So that is where the court comes under the POCSO. The court doesn't have any leeway in determining the amount of punishment that should be imposed. So ultimately, what the court does is that the court will say there is insufficient evidence that both of the offenders, or both of the victims, they will go to court. But then both of them, before that, once the offense, if the offense is filed, then both of the children are taken to the particular juvenile home, and there itself is again another traumatic issue for them when they are incarcerated in the children's home.
Recently, Delhi High Court has made a judgment like children who are engaging in sexual intercourse under 18 should be decriminalized. What's your opinion about that?
That's exactly what we were talking about. Definitely, you cannot say that both of them are they offenders, are they victims? So should the POCSO Act be applicable to them? Many judges of the lower judiciary let both the children go scot-free. because they are unable to determine who is the offender, who is the victim over here. Because it is a perhaps a case of experimentation. And that is where the exception would would be, it would be appropriate if such kind of close in age exceptions are brought into the law. Because two children within the age of, within an age gap of 5 years or 2 to 3 years, if they are engaging in sexual intercourse, it should not be criminalized. That is the perception in various countries like Hungary, Netherlands, Canada. So perhaps what the Delhi, I would agree with what the Delhi High Court stated regarding decriminalizing children from being booked under the POCSO.
Shortage of time, we would like to limit the questions. Is there any more questions? No more questions.
So I'd like to conclude by saying that POCSO aims to prioritize the well-being of child victims, ensuring that the abusers are adequately punished. But again, we have challenges in implementation and with regard to the cultural implications, whether certain things should come under the ambit of POCSO at all, or whether they should be excluded. Then with regard to one question that was asked earlier with regard to past crimes, a child marriage which occurred earlier, long time ago, whether it can be right now, can the offenders be brought to book right now? Those questions are there. And also with regard to resource allocation to ensure speedy justice. There are POCSO courts in different parts of the country, but not everywhere yet. It's been more than 10 years since the passing of the POCSO Act. But still, special courts with all the facilities have not yet come up in different parts of the country. So with these thoughts in mind, I thank you all for the patient hearing, and I thank the Department of Law for hosting me. Thank you, ma'am. We live in a society where different codes interpret child rights distinctly. This special lecture is very necessary, and we know most legislation relates to child rights. We can see the best interest of child. Ma'am said the best interest principles has been taken down, that is UNRC, constitutional articles, commission committees, and other state laws, which all we discussed right now, which ensure there are rights what are to be considered as offenses. Once again, thank you so much, ma'am, for your reflection on this topic. I truly appreciate you for your understanding. And meanwhile, Dr. Bharat thanks because the doctor is the University of Tamil Nadu to address what they have.
So thank you, Diana, for the opportunity now. So, though the country seems to be gender neutral, still it is we could see that the patriarchal form of society still exists. So I say that it was shifted to mathematical to take my home. Still, most of the decisions was taken by me, not my wife. So first of all, we have to respect the rights of women first. So before going to child, so we need to respect the rights of women. So the father of a daughter, wife of an husband. So they are taking decisions actually. So considering the females as a vulnerable. So even the COVID that gives a lot of insight and more positivity in many fields, but we can see the child and as well as the women, they have become most vulnerable. And there are a lot of offenses that have been against the women and children during the time of COVID and also during the post-COVID scenario. So that we can see through the statistical report of NCR, the National Crime Records Bureau,
So it was clearly stating that the offense related to child and women are more. And that was also explained through the various reports, and also we could see in the case of cyber crimes. So the crimes against the women is at large, and also the children. So now it is Professor Veera Matthew Ma'am for a wonderful lecture being with us for the MOU. Not only for the MOU, she also wants to express her deliberations on the topic of child rights. So she has nicely narrated the important aspects of the international convention and also the comparative style of various countries, for instance, Netherlands and various nations. So she also tried to look into various aspects of research openings to the young scholars like you. I believe the scholars of various departments and the PG students of the other departments will take a good chance to do more insightful research on this particular topic. So thank you very much for your insightful thoughts in this session, ma'am. And so I've been given this opportunity to another vote of thanks. It seems to be very difficult for me to express this vote of thanks. So first of all, I would like to extend my sincere thanks to our Honorable Vice Chancellor, who is a man of support. So though he seems to be considered as a young faculty, as sir rightly pointed out, Professor Ravindran sir is a man of humble. He used to give a lot of freedom for the faculty to decide on the departments. So this will never, the young faculty can never expect in the other departments. That much of freedom which is being given to us, that has motivated us, and also able guidance. And elderly guidance that is being given by sir is really much appreciable from the young faculty of the Department of Law. So thank you very much, sir. So I extend my sincere thanks to our beloved registrar, CUTM, finance officer, controller of examinations, dean academics, and various deans of other schools, and the head of the department, and the faculty, Dr. Kavya, Dr. Raghavan, and Dr. Shamala, and Dr. Ranjan Garg, and some other faculties from other departments, and also the research scholars from the Department of Education, and also from the other disciplines, and students from media, education, commerce, economics, law. So actually, this program is being meaningful only with the help of our law students. So they are really working hard from the day one to make an arrangement for this session. And also, I would like to extend my sincere thanks to our department faculty, Ms. Bhagya. So actually, this MOU has been into discussion for more than a year. So she was the person who was behind this MOU. So each and every word of this MOU was created by Ms. Bhagya. So and also she was coordinating this event right from the initiation to the completion of this program. So it's very much thankful for you, ma'am. And I also extend my sincere thanks to Dr. Sangeeta Sivan, though madam was on leave, but she's also instrumental in helping us in creating this program, and also Dr. Chandrasekhar. So, so whatever it is, we can sir will do. So not reading as a faculty, so he always we have a work and he's helping in all the sessions. So thank you very much, sir. So I used to thank the logistic support that is being given by electrical section, and also the IT section, and also PRO for his wonderful support throughout the program. And last but not the least, I should point out Ms. Mehra. So staff of the department, also Mr. Business, staff of LSS, so for helping us in making this event successful. So thank you once again. So thank you. Thank you.
Thank you, sir. And thank you all who gathered here for your enthusiasm and your cooperation. It's time to wrap up your lecture. Now, I would like to request all of you to write us the national anthem. those